Intelligent justice encourages you to ask some experienced attorneys whether they can match any of the specific advantages that our comprehensive adjudication system provides to parties seeking to resolve a legal dispute. They will tell you the advantages our system provides are impossible to achieve through litigation in court or arbitration.
Hello, this is Rick Grossman, founder of the nonprofit Intelligent Justice. If you still have questions about whether comprehensive adjudication is your best option for resolving your legal dispute after listening to my video posts, I urge you to conduct your own investigation. In fact, I urge you to contact the litigation attorneys you would hire to represent you in court or arbitration and ask the following questions. Ask your attorneys whether they can tell you now what the total cost will be to obtain a final enforceable decision resolving the dispute in court or arbitration. And ask your attorneys whether they will guarantee that it will not cost you 1 penny more. No honest attorney can do that because it is impossible to know at the beginning of the litigation process all of the obstacles that opposing counsel or the court will throw in your path in the years to come. But if your attorneys agree to a capped cost, ask them whether they will cut that cap in half. No attorney representing you in litigation can do that, but in a comprehensive adjudication, you are mathematically guaranteed that your cost will be less than half the cost of litigating that same dispute in court or arbitration. Because you are splitting the cost of a single adjudicator to investigate and decide the case instead of each side paying separate counsel to duplicate each other's work. Next, ask your litigation attorneys whether they can guarantee the maximum amount of time required to litigate your dispute to a final verdict. No honest attorney can do that because it is impossible to know all of the delays that will be caused by opposing counsel or the court in the ensuing years of litigation. But if your attorneys disingenuously guess what the total time requirement will be, ask them to cut that time frame in half. No attorney representing you in litigation can do that. But in a comprehensive adjudication, you are guaranteed that the time required to get an enforceable verdict will be less than half the time required to complete litigation in court because the comprehensive adjudication trial begins immediately instead of 3 to 5 years down the road. And the adjudicator has complete control over the timing and pace of the investigation. There is no opposing counsel or separate judge that can create unanticipated delays. Finally, ask your litigation attorneys whether you can interview the judges available to preside over your case to determine their experience, their neutrality, or their expertise in the legal specialty that is applicable to your case, and eliminate any that lack the necessary qualification. The answer you receive will be no, because judges are randomly assigned to the cases they decide without consideration of the factors that are most relevant to the parties in the dispute. But our comprehensive adjudication system allows the parties to jointly interview and jointly select the neutral adjudicator who will investigate and decide the legal dispute from a pool of distinguished candidates with particular training in the legal specialty that is relevant to your dispute. You have control because no adjudicator can be selected without your consent. Through your investigation, you will learn that none of the extraordinary benefits of a comprehensive adjudication are available to you if you pursue litigation in a public court or traditional arbitration. And your choice will be clear. In my next post, we will explore how your regular lawyer is likely to feel about the possibility that you might choose a comprehensive adjudication procedure to decide your legal dispute instead of traditional litigation.